Item number 5.
May it please your lordship. In this case, as per the directions of this honorable court, I have taken steps on respondent number 2 through registered post, and the service report is awaited, your lordship.
You have taken a step on 12th September.
No, on 15th September, your lordship.
But then the office note says 12/9. 12/9 notice issued upon respondent number 2 by registered post with AD.
I have the postal receipt, it shows 15/9, your lordship.
Yes, how can it be? See this. Come. How? The postal receipt is 15/9. Is it 12/9? I said 12/9. The learned counsel are taking post. Okay. It's all right. Okay. So we'll await for service report. Or what?
Your lordship, in the meantime, allow me to file a service affidavit bringing on record the
obtain
status report.
status first and
Yes.
then. Yes. It is submitted by the learned counsel, the petitioner, that the step for service of notice on respondent number 2 was taken by registered post. However, the AD card has not yet been received, not yet been returned. Stop. The learned counsel prays that he may be allowed to confirm the status of the service and file an affidavit of service.
A week
Just
time.
say learned counsel submits that petitioner may be, not this thing, not him. Petitioner may be allowed to verify the status of service and file an affidavit to that effect. We are allowed list after 2 weeks.
1 week, your lordship.
List after
File, your lordship.
Hearing item number 6.
But this matter, my lord, we had filed an additional affidavit, my lord. We had received the rejoinder to that affidavit, my lord,
yes.
yesterday. My lord, I could not go through the same. This matter is kindly taken up next week, my lord.
Yes.
Of course, it has been dragging on for some time now. It's okay, Your Lordship. Let it be taken positively on next week.
Was prayed for by the parties. List after 1 week.
My lord,
We should finish those matters if it is.
my lord, we'll finish it.
What is the matter about? What is the matter
This
about?
is regarding promotion, Lordship.
Promotion.
Yes.
Seniority and promotion or promotions?
Seniority and promotion.
Then what is the rule? Is it the what is the basis on which promotion is made? Is seniority come merit or merit come seniority or what? What is the rule? Is there any service rule?
Seniority.
Is there
come-
service rule holding the operating in the arena? Is there any service rule?
Service rule is there, my lord. But fact remains, my lord, here the main issue is actually, my lord, the bone of contention is the in the manner which the compassionate, because petitioner claims that she is been appointed on such and such post on compassionate ground, my lord. The contention of the state is that no, that appointment was not made because it was not as per laid down procedure and norms. Because there are certain criteria you have to fulfill, my lord, in order to get,
So how the petition was taken into service?
Yes.
my lord. So, however, my lord, at a
what is-
later stage, government had given some
How she came into service? How she
After
she
that,
came into
was there
service.
any recruitment process?
No, my lord.
Then
This is what had happened, my lord. The post had fallen vacant, and my lord, she was taken in as on the compassionate ground, my lord.
on ad hoc basis.
On ad hoc basis and
Under
on
regulation
compassionate ground.
3F.
it's not mentioning.
Okay,
order.
we'll take it up.
It is clearly on compassionate ground, Lordship. Not
See,
on ad hoc
if
basis.
appointment is made on compassionate ground, it has to be compassionate. It has to be regular. Cannot be something like that ad hoc. They should go by the scheme.
Right.
This is
What are the
completely against the rules.
We'll see to it. As straightforward the learning constable, list afterward. Yes. Come up
Item number
afterward.
7.
Authorised.
Yes.
Yeah, please. But here the petitioner is aggrieved by the termination of his services not once but thrice, and none of the termination orders being recalled at any point
Termination
of time.
thrice.
My lord, thrice.
Why you was after every termination you was taken back?
No, that is the whole issue, my lord. And the last termination order says you did not report to service and now therefore you are terminated. Now, once I was already terminated, the question of my having returned back to service would not have arisen. What had happened, in fact, is, my lord, the petitioner had availed leave. He had joined his services in 1974, and he availed leave. That lordship, and in his leave period, when he was returning home in 1993, he was initially arrested on charges of carrying drugs. Having been released on bail, he was abducted and could not report for duties. Now, this was in the knowledge of the respondents. In fact, the respondents in their affidavit in opposition, they admit to the fact that he had reported to the camp, but they had sent him back, and thereafter they had dismissed him. Now, lordship will kindly have the I will show from their affidavit in opposition the sequence that they try to lead and how it helps me.
What is your predate case? What is in your writ petition?
My writ petition, I have stated that all my terminations are wrong, and therefore I should
Have you mentioned about your arrest and all those
everything, my lord. And in fact, they have admitted that they knew about it, and they had reports from the concerned authorities that yes, I had been arrested and released on bail, that yes, I was kidnapped, and they have also admitted that I had reported back for duty on where they had sent me back without allowing me to join. May I just show the consequence, the sequence by the documents annexed by them and by me, my lord, which are part of records. Their records and my records. I'm just allowed that, my lord. Lordship would kindly have their affidavit in opposition, where, my lord, at annexure 1, page 24, they send an apprehension letter to the superintendent of police. This is what they have annexed, an apprehension letter. This, they say, was never replied to by the superintendent of police.
Okay. You disappeared.
My
you
lord.
disappeared.
To that, my lord, yes.
Yes.
Then lordship would have page 25. This is again a letter written, which they say to my family.
Page 25.
Page 25.
Annexure 1 is page 25.
My lord, in my copy it is page 24.
Oh, sure, 24. Yes. Okay, 25. Yes.
Page 25
Yes.
is a confidential letter which they annex of 18 December. This they write to my wife. As you are aware, an inland letter was received by this unit signed by one YG Sima claiming that Nayak Achelal of this unit is under his custody since November 1993. A ransom of rupees 50,000 only was demanded from this unit, and the money was to be paid by 15 December, failing which the individual was to be killed and his dead body brought to Kangla Park. Consequently, an individual of this unit was sent to the home of so-and-so to find out whether the individual is still at home, if not his whereabouts and the date on which he left home. It has been reliably learned through the wife of the individual, also from Gram Panchayat, that the individual had left his home on 6 November 93. His wife received 2 letters from him. Thereafter, the second letter was written on 20th November 93. CTC of the home of the same is enclosed herewith for a ready reference. From the office poststamp on the letter and also the text of the letter, it appears that the letters was posted from Bhagalpur. In view of the above, it appears all this is a hoax and that the individual may probably be involved in drug peddling and is making grounds for his absence without leave. Contents of the letter have already been passed on Colonel so-and-so, which is on tele by 17 December by me. However, he was requested the same in writing also. You
have framed a story.
My lord?
You have framed a story.
My lord, that is what they say on 18th of
this
December
letter says.
1993. That is what they say. Then lordship would find at page 32. Copy of the order passed by Sri Alok Kumar IS, Deputy Commissioner, Karbi Anglong Diffu. Seen the report of Deputy Superintendent of Excise Bokajan, Shyam Kumar, Ashok Kumar Chaudhary, Ashraf Ali, Achelal are produced under arrest under section 22 NDPS Act 1985, they are remanded to Hajut till 13/7/94. Seized ganja and personal belongings shall be kept in
You are
excise.
reading- you are
Malkhana
reading
GC
page?
office. My lord,
You
I
are
am reading
reading
page
page
32, my lord.
32. Yes.
The second order, my lord, dated 1/7/94. Seen the bail petition moved for bail of Achelal was arrested in the case. Advocate for the record or for the accused claims that accused so-and-so was on his way from Bihar to Manipur after expiry of leave and he has been falsely implicated in this case. Also heard PP as investigation is still at initial stage. Counsel for accused is advised to put forward adequate evidence of his claim. As on today, bail is registered as opposed by PP. We may seek information as to leave and movement of accused from his employer so-and-so. This is what they say they have the copy. So I was under arrest was known to them that I was in custody. This is what they...
What was your period of leave?
My lord, my period was leave was from 1/10/1993 to 20/10/1993.
For 10 days. 110.
For 20 days, my lord.
20 days. Yes.
20 days.
Now, when were you arrested?
I was arrested on while returning back on 17/10. I was kidnapped and
You said fast you were arrested, then on your release you were
no, my lord, no, my lord. I was when I was coming back to duty, my lord. I
That is your initial.
I missed. I missed it, my lord. I'm sorry. While coming back, I was first arrested, first kidnapped. When I escaped, they arrested me in an auto with 2 other persons.
So you were arrested on
28/6/94.
28/6/94. Yes,
much after the.
much after, my lord, because I was in this thing. I had spent the period in
24/6, isn't it? You said?
24/6. Yes, my lord.
96. And what about your absence from 2010 to say 21st 10/93 till 96?
My lord,
Period of absence.
I was kidnapped is the story given by the petitioner, that I was held in ransom.
Then you were kidnapped on which date?
My lord, I was kidnapped on 17/10/1993.
Before the expiry of your leave.
Before expiry, because I was coming back to join on 20th. I had to report back on 20th.
And you are kidnapped from?
I was kidnapped from at NSCN from Dimapur.
You are coming from here.
I was coming from UP, my lord, my hometown.
Then Dimapur.
Well, the train goes to Dimapur. There, from there, I have to take another convoy. That is what they're.
You are posted somewhere there in Nagaland.
To give the correct list of date, my lord, I was kidnapped on 17/10/1993. On 25/12/1993, I escaped from the militants.
You have a list of dates appended to the writ petition? No?
Yes, my lord, I have a list of dates, but that does not speak of that interregnum period, my lord. Just below the synopsis that I am reading from the writ petition, my lord, page 4, paragraph 5. Paragraph 4. I was kidnapped on 17/10/93, and at paragraph 6 I was arrested on 25/12/1993, and thereafter, my lord, I was released on bail in 1996, my lord.
On which date you were released on bail?
The exact date, my lord, I just find out. Exact date. Yes. In fact, my lord, I have written to them in 1995 that I am still in jail. Kindly arrange for my bail, etc. That is also on record. They have produced that copy at page 43. I was released in 1996, my lord. That exact date.
Your statement at paragraph 6.
My lord.
You said that you escaped on 25/12/1993.
1993.
Yes.
From the militants.
Yes. And then thereafter.
And while I was going back to the on the same day when I was trying to board an auto,
Yes.
I was arrested along with
You
other
arrested on
co-persons.
24/6/1996.
No, the 1996 I was released from jail. 1996 lordship will find the order is
No,
that
but
my
then that is what I probably you made a submission because you have made a note on that. So you were in custody for
more than
2 years.
more than 3 years.
3 years.
Nearly 3 years.
It's not 3 years.
I remained in custody for nearly 3 years, and it was in their knowledge that I was in custody because they have
Any document, court document to show that you were there in custody for 2 years.
my lord, lordship will find
Your
lordship
your
will
arrest memo, your production before court.
My lord, this order at page 32 that I read out, at least in 1994, my bail was rejected. At page 32, lordship will find at page 32, the order is dated 1/7/1994. The second order on page 32
Page 32 of the writ petition.
of the affidavit in opposition, my lord. I am trying to go by the
Becomes difficult. You see, like which way you see, like you are referring to certain documents which is not in.
No, madam, I'm not trying to refer to the writ petition because those may be documents which they would like to dispute. I'm trying to refer to documents which they have produced in their affidavit in opposition, because those are records belonging to them and they will not be able to dispute that.
And that is what you have pointed out before.
My lord, page 32,
32. Yes, order dated 1/7/94.
1/7/94. As on today, the bail is
No,
registered
prior
as
to that,
opposed
your
to
see, if your arrest was on 93,
93, my lord.
this is the order which you are referring. It is 6 months after 29/6 and this.
Yes, my lord. That is when
Just immediately after your arrest.
immediately after my arrest, my lord, I did not move any bail petition. I was not in a position. I
No,
did
but
not.
then if you do not make bail petition, doesn't mean that the court will not enter your appearance before the court.
The court
That
might have. Well,
this will
that,
be available.
well, that issue had come up. There might be an order on an earlier date. We were required to get the documents from the concerned court. at
Yes,
Dimapur.
definitely, that will
Well,
be
that order we had tried our level best, but with the differentiation of the now that has come up between the office of the executive magistrates and the judicial magistrate part, my lord, that record is missing. I could not trace it out.
Is it there in your affidavit?
That part I have not put it down in an affidavit. Otherwise, my lord, the records that they have, if lordship would only.
Anyway, I do not know if that missing link, these things are there. This will go against you. That is what the thing is. So because otherwise, allegation against you seems to be very serious. Very
the
serious.
unfortunate part is these allegations or if I may call it misconduct are not the grounds for terminating my services. Had these been taken into consideration by the respondents, or had I been given an opportunity to answer this before the respondents, that would have been entirely different case altogether. Whether there had been any proof in the criminal proceedings or not, if they could have come up with something in their order or something in their inquiry, even then that would be enough. The entire aspect was that I came home on leave and I did not report back to duty. Now, if I am able to convince this honorable court that my not reporting to duty is a false line of...
See, all along department had the knowledge about
They
your
had the
disappearance.
knowledge. So what they could have best done is either let me join, have an inquiry, finish my services. Perhaps that would have been another way of doing it. Second aspect is that you were absent on these grounds and this is what we believe, and because of your arrest or maybe because of your conviction, if there is any, if they could show, we finish you. That is another aspect. The only ground that they proceed on is you went on leave, you did not give any information to the department doesn't know what you are doing, we keep you on hold for 5 years and then we terminate you. It is before these 5 years ended that I indeed reported back to the company. Their affidavit in opposition, a specific statement on oath that he came back. We sent him away. On that ground, was my first termination valid at all? If my first termination was valid, they modified the first termination saying that it was not issued under the correct provisions of law. Therefore, I would have continued till the next order is passed. The next order, they say, it was again not in consonance with law and therefore we dismiss you for the third time because you never reported back for duty. The very ground that I never reported back for duty, if that goes, the entire termination goes. Now I am in a situation where I have already crossed the age of superannuation. There is no point of me arguing that my client could be taken back into service. But yes, if I am able to show that the termination was wrong, a continuity in service and my pensionary benefits being fixed, taking me to be retired on an appropriate date without giving me perhaps any back wages for the simple reason that I have not worked. But the notional benefits would be there. A man survives with his pension. And if Lordship would kindly have their statement in the affidavit, since Lordship already has it on hand, at page 6. They refer to OMs which are passed after the date of the order to say that our order was justified. Page 6, para H. That thereafter a letter dated 12/3/96 was submitted by the petitioner's wife was received by the respondents, wherein she had stated that she had deposited a sum of rupees 10,000 only in the Honorable Court of Diffu, Assam as security, and her husband was bailed out on 6/12/1995. As per policy in vogue issued by Directorate General Assam, so and so dated, now Lordship will kindly have the date, 3/2/2003. A soldier declared deserter without arms and ammunition is kept in supernumerary strength in the force for a period of 5 years and dismissed from service thereafter if he does not report for duty within 5 years period. The petitioner was declared a deserter in effect from 21/10/93 and was still in the supernumerary strength, and hence he was directed to report to the unit forthwith by the commandant 30 Assam's white telegram dated 9/5/96. I just pause here for a moment, my lord. They asked me to come back on 9/5/96 based on an OM dated 2003. Is it not putting the cart before the horse?
No,
Trying
there
to
is something-
justify their cause?
There is
Right. Now my lord, I go ahead. And letter number so and so dated 9/5/96. Now, the petitioner had reported to 30 Assam Rifles on 12/8/96. I reported back as they called me, without any document issued by the Honorable Court of District Magistrate Diffu, Karbi Anglong with regard to his court case for which he was jailed. As such, he was directed to submit the court case documents by 30 Assam Rifles dated 12/8/1996. I reported, they told me you bring documents. I am not allowed to, they don't say I am allowed to join. They send me back, they say you come back with documents, go.
Did you submit documents?
So The petitioner did not submit any documents with regard to his bail from jail or acquittal from the charges of drug trafficking and remained absent from unit without any information to the unit authorities. Therefore, now Lordship will again find. Therefore, in terms of the standard operating procedure on dealing with deserter cases issued by Directorate General dated 3/2/23, they repeat the date. The petitioner was kept in supernumerary strength till 19/1/1998. I pause here again. Per memorandum of 2003, they keep me in service till 1998. And thereafter was dismissed from service with effect from 2010-1993, again referring to 2003. So unless they show that there was some office memorandum in 1910-1998 allowing them to dismiss you from service in that manner in which they have sought to be done, and Lordship would also see the termination is retrospective, which, my lord, is unheard of in.
Now, the fact remains you did not submit your document with regard to your court case.
My lord, had that been the ground.
No, whether you submitted or not.
My lord, I have not submitted.
You submitted.
Because
Okay.
my lord,
So-
Lordship will kindly find.
And then
on
it's
12
like
at
you do not explain that why you have not submitted also.
12/8/1996, my lord. That part that I did not carry the documents.
Now,
with me
right
at
now
that
you are
point of
telling
time.
the court that these records are misplaced. But then at that point of time, I think records are not misplaced, isn't it?
That point of time, my lord, I will
So
have.
there
to,
was no effort by you to bring forward those court documents.
My lord, I have deposited, my lord, with them. They have brought it on record.
No, but then
Whatever I had, my lord.
they say the petitioner did not
The
submit any
records are there because Lordship will find at page 36. That is what they submit to the court, what I had in hand. The court records. If Lordship will kindly have page 36, my lord. This is their affidavit and this is the documents that they are presenting. In 1997, Lordship will find.
See, since allegation against you is very serious, so you
Yes,
have a
ma'am.
scrutiny.
Well, therefore, I am trying to place my reliance only on documents which they have produced. Lordship will kindly have page 36.
This is not at page 36.
Page 36, Lordship.
Yes.
Lordship will note the date at the top, 5/11/1996, 7/4/1997. These copies are got.
Yes.
These they have given. Copy of the witness of Sri P.I. Singh. Whatever documents I had, my lord, I had submitted. These are documents. These are the witness statements that I have with me.
So this is the document submitted by you.
Yes, my lord. It is in their records. They have not otherwise explained how they have come across these documents. It had to be submitted by me.
Their part will reply.
My lord, yes.
We'll just see.
So Lordship will kindly find that two aspects of their statements in their affidavits which say that they were depending upon an OM of 2003 to take action against me in the year 1998 and passing an order of retrospective termination. If I may read that line again, my lord, paragraph I. Therefore, in terms, I am reading from the fourth line from the top. Therefore, in terms of the standard operating procedure on dealing with deserter cases issued by Directorate General Assam
Paragraph
Rifle,
5 or
a paragraph I of page 7 of the affidavit, fourth line from the top.
yes.
Therefore, in terms of the standard operating procedure, fourth line from, on dealing with deserter cases issued by DG Assam Rifles letter number 322003, the petitioner was kept in supernumerary strength of 30 Assam Rifles till 1998 and therefore was dismissed from service with effect from 2010-1993.
Yes. Which
So,
effect?
two factors come in, my lord. I could not have been dismissed with effect from 2010-1993. The termination order could have effect at best from 1910-1998. There could be no retrospective termination of service. First issue, my lord. The second issue is, and
Even if you are declared deserter before
my
that.
lord, yes, the Supreme Court has been very clear on this, that any termination of service has to take effect from the date on which the order of termination is passed. A retrospective order does not become, my lord, ineffective totally. The termination stands, if otherwise correct, but the effect has to be from the date of order only. It cannot be a retrospective effect. My lord, I can place the judgment on that line. So at best, the effect could be from 1910-1998. Now the explanation that they had depended upon an OM of 3/2/2003. That shows that this is an explanation which is sought to be given after an afterthought, depending upon an office memorandum which came into existence after the order of termination is passed.
Now, what was the situation before this standard operating procedure was in force?
3/2/2003. Prior to that, my lord, prior to that, they have not given any explanation in the entire affidavit in opposition on what they have based their orders on. Taking the affidavit in opposition on the face of it, the explanation cannot be correct. My humble submission, my lord.
And that is very unusual. How come 3/2/2023 we relied on? Say,
Well, because they, in my humble submission, because they did not have the any standard operating procedure at that particular point of time, and they had to say something before this honorable court. This is what we try to depend upon. This is exactly, my lord, what was perhaps deprecated by the Honorable Supreme Court in the case of Mohinder Singh Gill, my lord, that you will not explain by an affidavit what you did at a particular point of time. Your explanation in an affidavit will not support the case of the respondents. They cannot try to explain an order.
document will basically.
Whatever was the document, now the document by which they seek to, by the document by which my services were terminated. Prior to that, my lord, if lordship will kindly have page 43 for a moment. Page 43
of
the affidavit in opposition. I am not referring to the writ petition at this moment. I am just referring to their documents to show that it is their documents which show that they had knowledge and the very basis is gone for passing any of the termination orders. Apart from the fact that those termination orders were not sustainable in law for other reasons also. Page 43.
yes.
This is a letter, my lord, which they annex and which they acknowledge receipt. It says it is signed on 8/5/1995. I have the honor to state that I am Nayak Achelal, son of so-and-so. Dear sir, respectfully inform you that on 17th October at 4:30 am I was kidnapped by some unknown person from Dimapur near railway crossing while I was coming back after spending my annual leave of 30 days. They were 5 in all, having sophisticated arms, also in a Maruti van of white color AF number plate. They made me forcibly to get in the vehicle after getting tied my eyes so-and-so. When I was ordered to get down, it was 45 minutes. Later, walking by a few minutes, my eyes close was removed. I found myself in hut. I was asked for rupees 50,000 as ransom and address of commandant. The address I had to give. After 1 month, I was told we are not getting any money from an official. We are going to shoot you down. Is there anywhere else you can get money? Was the question. There was no way out. I gave them address of my home as well as letter to my wife for arrangement of sum on 25th December. They told me only 35,000 they got arranged for the. I made the escape from their imprisonment on 20th of June 1994. In the morning, I found myself Karbi Anglong district Bokajan, intended to report the nearest PS after having a rest. In the evening, I made myself to report to police station. On the way, I found a police check whereby a car nameplate SDO civil on it was parked. I went to the police personnel as I could have reached to them before. I was surrounded by excise personnel along with official whom I later came to know as SDO civil. I showed them my identity card and belonging documents, also narrated my story, but they did not believe me. I was suspected to be a smuggler of ganja and sent to Diffu district jail as smuggler. Though nothing was found illegal with me, since then I am in Diffu jail. I have made several correspondence to reading official. No step has been taken by now. I shall be thankful to you if you please pay kind attention toward this poor fellow who is serving his nation honestly. Herewith attaching the copy of my charge sheet. This I give to them in 1995. They acknowledge receipt.
What is the date of this?
On the next page, lordship, page 44 is the signature down below the date. It is 8/5/95 if I am not wrong, my lord. Just below the signature.
It is hardly
Legible, my lord. They might have the original of it.
It's okay.
Then on the next page, their document, my lord. At page 45 is a translated copy, and page 45 is a letter written by my wife on 12/3/1996.
This is in Hindi.
This was in Hindi. At page 45 is the translated version given by them. There, my lord, at page 45A, just the second last paragraph.
Page 45A.
A, just prior to page 45.
He has come before.
This was to Director General Assam Rifle from my wife, and this was dated 12/3/1996. Second last paragraph. Honorable Diffu Court examined the report of SDO PK Bora and report of witnesses from the advocate. According to witness report, FI and SDO report, my husband was not in possession of any illegal contraband item and my husband was illegally kept in jail for 17 months and 18 days. I request you to take legal action on the same. As on date, I am a debtor of rupees 45,000 that as I have taken loan from others and our house is on the verge of auction or sale. I am bringing up my children by begging. I cordially request you to send me a sum of rupees 45,000. That is 35,000 paid to NSCN and rupees 10,000 deposited at the Diffu Court so that I could be able to get myself free from loan. I hope you will definitely think about our children so that I am able to bring them up well. For this act of kindness, I shall remain grateful to you. This was in 1995. Then Lordship would find
This
the
is
standard
96. 12/3/1996.
12/3/1996. Then Lordship would find that they have given the standard operating procedure of 2003 that they have been referring to, which, my lord, in my humble submission, did not apply in the year 1998 and could not have been resorted to even in the year 2001.
Now the question is that which was in application into 1998.
My lord, that perhaps they would have to bring on record because there are certain limitations that the petitioner faces, my lord. Whatever is available either on the net or what is made available as publicized rules, my lord, or notification, that only we are able to get hold of.
These are public documents, isn't it? These are not secret documents.
My lord, very difficult to actually get hold of. Normally, these are the documents that till 1996 at least, the department was in complete knowledge of what was going on with me. Whether I carried a contraband or not, whether I had overstayed my leave, whether I had made a false statement of being
No, that is,
kidnapped,
you are
all-
saying, see, your submission is based on these letters.
Yes, my lord.
Now these letters has been written.
Has been? My lord.
With what motive? Who knows?
My lord, yes. Had there been
Who knows? You were in collusion with your very
very well a possibility.
Right from the beginning,
My lord.
just frame the story.
My
It was
lord.
required.
My lord.
So it was all kind of, like
A make-believe thing to perhaps distract the department or to have a story where I could go back to Japan. My lord, had that been the charge or had that been the basis of my termination from service? My lord, I am coming back to where, my lord, I would like to address this court on whether under Article 226, the petitioner has any capacity or does he have the right to argue the justifiability of a punishment or the justifiability of the decision made by the authority. That I do not have.
Definitely not go into the merits and demerits.
We are not on that.
We are confined to the decision-making process.
My lord, yes.
That is-
Now the decision-making process.
That is what the normal thing. See, but then, even sometimes for applying law,
My lord.
we have to first know the fact.
So, my lord, the facts which is before this court is that I had taken leave. I did not report back in time.
You have overstayed the leave. That is what.
I overstayed leave. I was.
Then, if you go by their first annexures,
My lord.
they have issued that what do you call it?
Apprehension rule.
Apprehension rule.
My lord, yes.
So, meaning thereby, till that stage, department had no knowledge about your whereabouts.
Whereabouts. Very correct.
Now, that has been issued in December 1993. 2nd December.
December 1996, my lord.
Now, if you want to contend that department had the knowledge,
No, this apprehension rule was issued on 2nd of December 1993.
yes,
Yes.
your leave was on October only. Your
October.
Yes.
Now, immediately thereafter, when they come to know that I am in jail for a
Now,
crime,
when they come to know in jail,
Madam,
as
that
per their affidavit, when
When they come to know?
1994, my lord. At page 31 of the affidavit.
Page 31 is what?
Page 34, my lord, is a letter
Page
written.
You are referring to 31 or 34?
My lord, page 31 is a letter written to the superintendent of police.
No. Yes. When the department came to know about your whereabout, like when they came to know about that you are in custody.
Page 34, my lord.
Page 34.
18th of July 1994. This is written by to the company commander by the subdivisional officer Bokajan regarding my arrest, regarding my detention in jail.
That is 5th July 1994.
My lord, it is
Page
18.
30.
Page 34.
Problem in pagination.
Government of Assam, Office of the Subdivisional Officer Bokajan. At present, Sir Chelal is lodged in Diffu jail awaiting trial. 1994, they knew that I was in custody.
And then when they declare you deserter?
They declared me deserter in they say they say he was declared a deserter with effect from 21/10/1993 by order dated 14/2/1994.
Prior to that.
14/2/1994, they declared me a deserter. Now, when they come to know that I am in custody, had they taken the action on the basis, had they no knowledge after the declaration, if they did not have any knowledge regarding my being held up in custody or wherever I was, or had they taken an action on 14/2/1994 immediately thereafter, it would have been a different proposition of law or of the circumstances. That they declared me a deserter, then they go ahead to dismiss me.
Did not get the thing. Just repeat the submission. What
Well, if they had taken some action on 14/2/1994 before having any other knowledge of my arrest or my being detained.
No, you were declared deserted on which date you said?
14/2/1994.
14/2/1994.
14/2/1994.
Yes. Where is that?
My lord, at page 4 of their affidavit in opposition. And the orders is at and though they refer to annexure.
It's all right. Once we get the date, it's okay. We just
Yes, at page 28 is the declaration. Although they say at page 4, the top paragraph, court of inquiry with regard to his unauthorized absence was also finalized on the basis of a findings and opinion. He was declared a deserter from service with effect from 20/10/93 by Commandant 30 Assam, and a casualty to the effect was published in 30 Assam Rifles dated 14/2/1994, which is annexure 3. If we have annexure 3, my lord, it does not declare me a deserter, it simply declares that I am illegally absent. At page 28.
What is the difference?
My lord, a deserter and a illegally absent being two different terms in the Act and Rules. Perhaps I'll have to.
It's all right. It's all right.
Just on that, although, but they are taken to be different terms. My lord, illegally absent may also have situations where my absence may not be willful, but without authority, where I am restrained by an accident or maybe by a death at home or something. then I remain illegally absent. But when the intention is not to serve the force anymore and run away,
Deserted means
that
something
would be a
something
deserter.
willful.
So the declaration here is declared illegally absent. Although they try to frame it up in the affidavit of opposition as an
So they declare illegally absent means unauthorized. Unauthorized.
so it was not a it was not a declaration of deserter as such.
There
for
will be
the
huge difference.
office note also, my lord. So now, my lord, if lordship kindly has the orders by which I was terminated time and again. The first order lordship would find in my writ petition at page 20.
Now you are referring to your writ petition.
My writ petition, my lord, because that they have not given in the affidavit in opposition. Retrospective termination has a judgment on his permanent no retrospective termination to allow judgment to Salah.
You are referring to page
20, my lord, the first termination order. It's 29/7/2003 lordship finds that whereas so and so who was absented himself from leave overstayed leave granted to him, now lordship will see they have not struck out which part I belong to, has absented himself from leave, overstayed leave granted to him, oblique deserted the unit with effect from 20th of October 1993 and is still absent. That after expiry of 30 days of his absence, a court of enquiry under section 106 of the Army Act 1950 was convened to investigate into the circumstances in which the above individual became absent, and the said court of enquiry declared so and so to be a deserter. That an apprehension rule dated 2nd of December 1993 was also issued in respect of so and so in the district magistrate of the district to which the said individual belongs to apprehend him, but till date he could not be apprehended nor he surrendered to any army some rifle absent authorities and is still absent. Now lordship will kindly see neither he could be apprehended nor has he surrendered to any Assam rifle authority. And I had just shown lordship that their affidavit in opposition shows that I had reported back for duties. I had given them the documents which were with me in 1997 and is still absent. A total period of 5 years has elapsed since his absence. I therefore, taking into consideration the entire circumstance of the case, am of the considered opinion that further retention is not warranted. I therefore, by virtue of power vested in me under section so and so, now lordship will find they write section 4A of the Assam Rifle Rules 1941 dismiss so and so with effect from 20th of October 1993. Now there are 2 or 3 things which I would like to point out. First of all, in the first paragraph, he does not specify whether it was absented himself from leave, overstayed leave granted to him, or deserted the unit. That part remains to his choice. Thereafter, lordship will find that he was deemed to be a deserter. The court of enquiry report or the casualty form at page 28 does not show that I was deemed to be a deserter. Paragraph 3, my lordship, he says that he was not surrendered to any Assam Rifle authorities, my lord. I had reported in 1996. I was sent back 1997. My documents are there with them. Whatever documents I had, that this was the evidence given. And lastly, my lord, they refer to section 4A of the Assam Rifle Act. Now, there was no section 4A of the Assam Rifle Act at that point of time.
This provision was not in existence.
4A was not there. There was nothing called a 4A. So therefore, my lord, this order now comes to be reviewed. Then lordship will find at page 21. I make an application. Kindly reinstate me. And they write to me in return at page 22, my lord, if I may read the Hindi portion. आपको सूचित किया जाता है कि आपको इस यूनिट में आने की जरूरत नहीं है. In 2003 they tell me आने की जरूरत नहीं है क्योंकि हमारे यूनिट की तरफ से जो ऑफिशियल कार्रवाई थी उसको पूरा करके महानिदेशक शिलोंग को भेज दिया गया है. So I'm asked not to report back anymore. In 2003 I'm told you need not come back here anymore. Thereafter, my lord, I had made a writ petition at Allahabad.
Why at Allahabad?
My lord, that very question came up and the writ petition was dismissed in due to lack of territorial jurisdiction, my lord.
In Allahabad.
He had the idea that he was serving in, he had his home at UP and Allahabad. High Court could try it. And therefore, my lord, lack of territorial jurisdiction, it was dismissed. Now, my lord, at page 24 comes the next order of termination.
Page 24.
That whereas so-and-so, who overstayed leave granted to him with effect from 20th October 1993 and is still absent. Now, Lordship will kindly recall the letter at page 21, where they said you need not come back to this office anymore. Page 21 was the English version. I had read out the Hindi version, my lord.
Yes, yes. That is 3rd December 2020.
3rd December 2003, they said that you need not report back to this place anymore. In 2010, the stand taken is that I am still absent. That after expiry of 30 days of his absence, a court of inquiry under section 106 was convened to investigate the circumstances in which the above named individual became absent, and the said court of inquiry declared so and so deemed to be deserter. Lordship will find the language remains exactly the same in the second paragraph, the deemed to be deserter part. That apprehension rule number so and so was issued in respect of so and so to the district magistrate, to which the said individual begins to which the said individual belongs, to apprehend him, but till date he could not be apprehended. A period of more than 5 years has elapsed. Now, taking into consideration the entire circumstance of the case, I am the considered opinion that further retention is not warranted. I therefore, by virtue of powers vested in me under section 4.1, this section 4.1 is the correct section now being named. It is named correctly now.
It was not 4A.
I am not saying that it was exercised properly. I am saying that it is now nomenclatured properly.
So 4.1 was there at that time.
4.1 was there, and
It was not 4A.
in their affidavit in opposition, they take a stand that 2010 was issued to correct the mistake of 4A. That is the stand in the
Would have
affidavit.
been a clerical error only.
Could be, my lord, but it was after 7 years.
So,
Taking into account the fact that I was still absent.
NI.
My lord, that I was still absent. Therefore, the letter is at 2003 asking me not to report back for duties.
It's a replica of the same earlier one.
But the fact that in 2003 I was asked not to report back for duties any further, not to report back, was not taken into consideration. So my absence from 2003 to 2010 has been taken against me, that I still remain absent despite the fact
When
that I
you were
was
asked to not to report back, you did not challenge it.
my lord, that was the time when
Whether that kind of order could be passed or not.
my lord, that was what was challenged in Allahabad in 2006.
No, but then thereafter, after dismissal,
My lord, that was what was challenged. If Lordship will find it, page 20, page Annex 3, my lord. Allahabad, I challenged it, and I did not have the.
after Allahabad declined to entertain your
Entertain, my
petition for want of jurisdiction.
My lord, at that point of time,
Thereafter-
what has been given to me is that it was the distance and the pecuniary aspect which did not allow him to come back to the court at that point of time, my lord, to the appropriate court, at least to the. Now, my lord, thereafter, once I received the 2010 letter, immediately thereafter they issue another letter. Now, this 2010 is a wrong letter. Why I will say so is, my lord, this honorable court has held, and it is now also the settled position in law, that the commandant, Lordship will see down below the commandant.
Yes.
The commandant was not authorized to issue a dismissal order for a Nayak. It had to be done by the DIG, so 2010 was also wrong.
There is a decision to that.
Yes, there is a decision, and they have admitted it that commandant was not the authority to have issued the termination order to
That
a
is
Nayak.
why they corrected it again.
Now they have corrected it in 2011, Lordship will find, at page 25.
Yes.
That whereas so and so has overstayed leave granted to him with effect from 20th of October 1993 and is still absent. That after expiry of 30 days of so and so, they deemed to be deserter again is repeated. Apprehension rule is repeated. Is still absent, and paragraph 3, the last line, my lord, is still absent. Period of more than 5 years has elapsed since his absence. Taking into consideration everything, He dismisses me, my lord. Paragraph 4. I therefore take into consideration the entire circumstance of case and of the considered opinion that further retention of so and so in the force is not warranted. I therefore, by virtue of powers vested in me under section 11(2) of the Assam Rifle Act and Rule 25 of the Assam Rifle Rules, dismiss so and so with from service with effect from 28/1993. Now, my lord, my challenge is to this particular order.
So there were actually, in fact, no 3 dismissals. There's one dismissal, but then stood corrected in every stage.
Every time they stand to correct it. Now, my lord, what happens is the dismissal from service with effect from 20 October 1993, my lord, as held by the Supreme Court.
When did you file the writ petition?
My lord, I filed this writ petition in 2019, my lord, because thereafter also I had.
2019?
Thereafter also I
But
had.
there was appeal, any appeal, provision of appeal against the.
They have not appealed that.
Hmm?
They have not appealed that.
No, is there any studied provision of appeal?
There was, my lord, by now at this stage, my lord.
I do not know.
What
You see, you
happened
have to
that
say,
day-
just my concept from normal
that
service.
The scope of an appeal is always there, my lord. When the
After
order
that
is passed with the
There has
DIG,
been appeal, no.
my lord, that appeal I do not think has been
Well, here
appealed.
what happened,
Not on my record, my lord.
My lord, here what
Please,
happened?
you have to give me. this
After
thing.
that, he again went to Allahabad.
Allahabad High Court, my lord.
That order is
That order is here, my lord. I had approached the Honorable High Court originally.
Even knowing that there is no jurisdiction.
second time they entertained, my lord.
This is
Then, my lord, it was.
anyway. This will take when we'll hear when you reply.
So, my lord, this. Then I had again approached the Honorable High Court, Allahabad High Court, and by order dated 2012-2017.
Now the first writ petition filed by you in Allahabad High Court
My lord,
was not entertained for want of jurisdiction.
jurisdiction, my lord, yes.
Now then second you again.
My lord, thereafter there was a change of there was a change of law brought in by Nawal Kishore Sharma.
What does it
Nawal
say?
Kishore Sharma, my lord, says once a person is terminated from service and if his representations or other documents are available are addressed either to the home to the place of his residence, or if he is terminated and asking for pension or other benefits, then, my lord, the other court would have the territorial jurisdiction. That was a judgment rendered by Honorable Justice R. Gogoi, my lord, and has been followed in several other cases. Perhaps it was on that basis that this was initiated in Allahabad High Court. That was an order. That was a judgment of
We
2016.
will not go and examine it. And seems Allahabad High Court had entertained that. thing.
Entered to some extent, my lord. At page 27 is the order. Where, my lord, it was directed that he would file a representation to the respondent authorities for payment of terminal dues. May I read page 27, my lord? In this writ petition has been filed for mandamus directing DIG Assam Rifles Headquarters Manipur Range to pay entire pay and terminal dues of the petitioner. It has been stated that the petitioner was appointed as a rifleman on permanent basis in Assam Rifles on 26/4/1974. However, he was terminated from service by an order dated 29/7/2003. Termination order was from retrospective effect from 2010/1994. However, during service period, certain deposit of petitioner were not paid to him. The petitioner has made a representation to this respect, which is pending. The petition is disposed of, directing Deputy Inspector General Assam to decide the representation of the petitioner by a recent order within a period of 2 months from the date of production of certified copy of this order. Petitioner is given liberty to file fresh representation along with other relevant papers and a certified copy
So
of this order.
termination was not a question there.
My lord.
So can you raise
Thereafter-
it now?
My lord. Lordship will kindly see. Lordship will kindly see the order that was challenged. There was an order of 29/7/2003.
But then the fact remains this order was passed in 2017. This Allahabad High Court order.
The other orders, my lord, were perhaps not brought on record
See,
before
now
this
the
honorable
thing
court
is
and
that
not challenged.
Question by the court is that
My lord. My lord.
if you omit, say supposing in this petition, I do not know what your prayer was exactly in before Allahabad High Court,
Yes.
but then so far as the order is concerned, it says that your prayer was for pay of
Terminal
entire pay
benefits.
and terminal dues.
Terminal dues.
So your termination was not under challenge. The termination, the fact
that-
is you have
that-
been,
that- that is-
you have
that is
been
not the
dismissed
prayer.
from service.
that is
Can you make it now?
My lord, unless
Can
the
you make it now?
my lord, unless the entire unless the termination order is challenged, there can be no prayer for pay or terminal dues.
No,
Once-
then
once
then
it's a
what
case of-
basis will determine it?
It's
See, your termination of service order dated 29/7/2003 was
Madam.
in thing.
Madam,
But
yes.
then the fact remains this writ petition was filed in 2017.
17 years, madam.
So
The delay.
now
the-
you omitted, say supposing if
because
you omit.
in 2017, my lord, in 2018 is the last order passed by them where I had made the representation, and the last order passed by them, my lord, they say that these are the termination orders and therefore you are not entitled to anything. And it is that stage, my lord, I come before this honorable court because lordship will find at page 31.
No, that is okay.
Is the final order passed by them?
The fact remains that in 2017
My lord,
you prepared a writ petition. There you omitted to challenge
my lord.
your dismissal from service. Can you now make that prayer? What is the position of law? Say supposing
I-
certain reliefs you were entitled to at certain stage and you omit to make that specific prayer.
My lord, yes. Well,
Can you subsequently make this prayer?
my lord,
What would be the position
what
of
is falling from lordship is that when I ask for a relief, it has to be a consolidated relief, claiming all the reliefs that I want, and I will not be able to break down my reliefs.
that is
to
what
ask
the
it
normal
at different
normal
point
concept.
of time. My lord, that aspect I'll
You have to.
possibly
You have to.
I have
Otherwise,
to deal with that
otherwise
aspect.
will not allow you to this.
I
Please,
understand.
please.
I understand. That would be the first hurdle now for me to cross. That when I had made a prayer in the Allahabad
When
High
you
Court,
omit to make something.
and no, when I had made a writ petition and I did not make a certain
First, you
prayer,
verify your writ petition there. Just
lord.
see
My lord.
if that prayer is there, and you, when the court did not entertain it, whether that will remain-
that aspect will
whether
then
you can
come in.
renew this prayer. Second thing is that
if I did
if
not
you
make it,
fail
then
to omit. If you do not make any prayer
My
with
lord.
regard to your dismissal, can you make it now here?
in that case, my lord, I'll. have
That
to
is the
seek-
question of law. You have to answer.
I understand, my lord. For that, I'll have to.
Before you entertain your submission or your prayer for
My
this
lord,
thing,
my
so
lord.
you have to be clear on that part.
Understand, my lord. May I pray, my lord? Then I'll have to seek some time to go into that aspect of the matter.
For a
I
lawyer like you, I
apologize for
don't think
that.
that there will be any difficulty to find out it. Anyway, but then definitely there is, of course, we have
One opportunity to find out whether I can.
Mojika objects to it. I do not know.
Let me also submit something, my lord. My lord, after this order was passed, the relief was very confined, my lord. He was allowed to submit a representation with regard to his terminal benefits. And then he submits a representation, my lord. Kindly see the representation, my lord, in the writ petition. Relief again confined to terminal benefits, my lord. Now, pursuant to that, a speaking order has been passed, saying that he is entitled to some money, my lord, that has been mentioned at page 32. That
That
is
is
entitled-
exactly, say supposing if there is a bar posed by law, then we will not go and entertain, even we will not go to the question of the dismissal. We will not even try it.
But it-
Only
my-
will confine himself his claim with regard to his claim, with regard to those terminal benefits, nothing else. We will not.
Secondly, my
the
lord,
writ
what-
petition
what-
scope, the writ petition will be confined to that.
What is more glaring, my lord, in this case, my lord? I'll just take your lordship to one page in my affidavit, my lord. But whether your lordships will entertain into such disputed questions of fact, my lord.
That is definitely, this court will not, definitely not. If there
Because,
is-
my lord,
Anyway, see, I don't think Mr. Majumdar has correct. Mr. Majumdar, yes.
My lord?
Isn't it? Yes. Have I uttered your name correctly, Mr.
Yes,
Majumdar?
yes, my lord.
Yes. Because I have seen you in the bar, so there is no this thing you said.
my lord, what happens, my lord? The dates are so confusing, my lord, and this is a totally concocted story, my lord, that he has
Confusion,
been.
it court
he has
finds
been
it
kidnapped, my
confusing.
lord.
Court will never go and venture in those
My lord,
areas.
page 25, my lord, in my affidavit, lord, so kindly.
You're also referring to your affidavit.
Yes.
The learned
That I had
counsel
read.
for the petitioner
That was the document I started with.
relied on your affidavit to make his argument. I thought you will rely on the
He
writ
didn't
petition.
read the entirety, my lord,
I
that's the-
started with this. I started with this letter, if lordship will recall.
Page?
Page 25.
25. The ransom note part, where it was said to be a false story. That is where I started with.
Yes, that is what. Page 25.
My lord, the para 2 is more pertinent here, my lord. What it says, my lord.
Yes.
Consequently, the individual of this unit was sent to the home of petitioner,
Yes,
my
yes,
lord.
yes. I've gone through that.
And his wife informed him that he left from his place in UP on 6th November
Yes.
1993, my lord. Then his wife has received 2 letters from him thereafter,
And the second letter was written on 20th November 93.
Now, if he is left, if this says supposing,
My lord.
we cannot treat a document partially correct and partially incorrect. It has to be either wholly correct, wholly incorrect.
My lord, my only
Now,
emphasis,
say supposing if any reliance is paid with the learned petitioner,
my lord,
counsel for the petition on this letter, then we will assume this entire contents of the letter to be correct. Now, then that part that the petitioner left on 6th November 1993
my lord.
will definitely
Go against
disclose the entire factual story, because he says then he was arrested on he was kidnapped on 17th and 1990.
My lord.
1990.
Now, if he was in
And he leaves from his place on 16th November, my lord.
yes,
And
then
not only that, my
no
lord.
question, no question.
Not only that, my lord.
Now,
the-
you see, probably this
he
court has
sends a-
noticed
he-
all those things.
He
It's
sends
not
a
that-
letter on.
Yes,
He sends a letter on 22nd November from Bhagalpur, which is in Bihar, my lord.
yes, that is also. Anyway, you will point it out all those things,
all
because
those-
this court
therefore-
will have to note those facts.
My lord.
Otherwise, there's so many disputed question of things. There's every likelihood we may miss something.
My entire submission was on the basis as to whether the orders which were passed by them were in exercise of the powers which are conferred on them, and whether it could have been done in the manner it has been done. The truth, how do I say, the magnanimity of the crime itself, the offence alleged, was an offence alleged against me, was something proved against me, nothing doing. It is, you are absent and you go home. Absent without informing us. Did they have the information? Did I
Okay, but
inform?
then we are again coming to the question of dismissal.
Therefore,
Now, the whether that you
the
can
only
is
point-
open for you. If you omit to make this prayer before Allahabad High Court,
then
or say supposing if you had made it also, but the
And it
court
was
has
not
declined to enter. If this order is silent, the assumption is that court had declined to give that.
Declined to
But
give
can
it.
you
That-
can you renew this prayer?
that was exactly a point in my starting days, my lord, in before Justice Sharma, B.K. Sharma sir. He pointed out that what has not been granted is deemed to be rejected, and therefore I was rejected the entire back wages.
That
And
is what
when I learned that, my lord.
the normal understanding of law.
Yes,
Unless
yes.
you prove.
Yes. Therefore, when it fell from lordship, my lord, I was taken a bit back, because I knew that if it has not been considered, it stands rejected, and I will not be able to agitate it now. Therefore, my lordship will only give me an option to find out from the
This is definitely
pleadings
this
in
is a question
the.
of law. And I
before
think
the
Mr.
Allahabad High
Majika
Court.
also will definitely come
Yes,
with certain
that part,
decisions. Against that, yes.
It
Because
has been
speaking
there
of-
from 2019, another date, my lord, would not. I'll just try to find out if I can,
No,
if it was
try to
done,
find
and
out, try to find out.
how do we address it. That is what I'll just try to find out, my lord.
When you will come back?
Could lordship have it on sometime in November, my lord? November.
I will have not. This court will not have. I do not know. But then if you come back in November, then you have to again repeat your submission. By that time, this court will forget everything. See, I do not. I am taking a number of matters. But then right now, I have shortage of PAs also. One has taken leave, and dictating order also has become. And you understand that I am a new judge, so I have to be extra careful while passing judgment.
My difficulty was, my lord, in the month of October, my daughter is having her national games. She is preparing for the national games. I would not be here for the first 2 weeks.
Then, see, like if Mr. Majika,
Well, I'm here, my lord. I'm at their
your
mercy.
daughter is taking part in national games.
My lord, she's a shooter.
Which event?
Shooting, my lord. She's the.
India's world ranking is very good in shooting, isn't it?
Yes, my lord, and she's the gold
They
medalist in
cannot perform
the.
in Olympics. In World Championship, they can. But
She's the gold medalist in the Northeast, my lord, the zonal Olympics.
very good.
She held the gold medal, so she wants me to accompany her
Yes,
in the month of October.
should encourage her always.
All these years, my wife was doing it. Now
See,
she wants me
Majika,
to
Mr.
do.
Majika, see, he's going for some novel course.
Oh, no problem. October is a bit tight.
So just simply it.
I'm also clearing 15, 16, 17 matters.
But then
my lord.
take note of these things which you have to.
My lord.
Please.
In any case, my lord, I'll remind the court on that day, my
You
lord,
have to.
regarding this
There is
part,
no
my lord.
chance. No, otherwise, also I have a forget.
This Allahabad High Court, my lord, once I bring it on to lordship's notice again, perhaps everything will fall into place again on that day.
So far as question flow is concerned, but the factual aspects will be.
If that part is decided, my lord, against me, the factual part would not matter much thereafter.
But then why your thing 2019? Why after so much of delay? That is also one thing.
Why, if you are at all, even if you go by the last communication 2011,
My lord.
why in 2019 you are changing?
He's actually a washerman by trade. Doing those things in UP.
Now say supposing if the vacancy created by your dismissal is filled up.
But therefore, now since he's already crossed the
reached
age of
superannuation.
he's crossed the age of superannuation, the best relief that I can pray for him is a continuity in service till the date it is decided till the date he attained his superannuation, and calculation of, if Lordship sets aside the dismissal, then a notional calculation of his pension, which would be a few thousand rupees given the scale he joined service in 1974. So that minimal relief would come to him. No joining back in service as of date.
Anyway. So we will not pass any order of in details. We will just say the issue which has been raised will not record anything. Anyway, just spread for by the London Council for the petitioner. It is this matter after.
4 weeks would do, my lord. 4 weeks would be end of October. I should be back.
After 4 weeks.
I'm obliged.
Who is the other side? Who is your other side?
I'm there.
I'm 14.
With their reply, then it's okay. Otherwise, if it is not, then Lordship may kindly give us a date and fix the time accordingly and the last opportunity, because for many dates they are not coming with their reply, and that too they will not be able to, Lordship, reply my petition for the reason that there is a technical legal issue. There is a statutory bar in Section 8 of the Prevention of Corruption
What is
Act.
the matter about, Mr. Majiga?
My lord, this matter was
Lordship,
heard by.
Yes. One second, Mr. What reply is to be filed by you?
My lord, what happened, my lord? This matter was heard by Justice Dingdo, my lord.
Yes.
At full length, my lord. Then Justice Dingdo was of opinion that I should file one affidavit, my lord. Now, my lord, since the matter has come before your lordship, my lord, in my humble submission, petitioner can make a submission. If lordship feels that some affidavit is required, I'll
If
file
there
it.
is an order, then you have to. We cannot ignore that order.
And what happened?
It
Well,
is Lordship,
it skipped my notice at that point. Skipped my notice, my
When
lord.
I submit, they are telling absolutely false before this court. It is they have sought time.
Please
to
mind
file
your
a
language.
reply.
Please mind your language. Please mind your language. Please mind your
They have
language.
sought time, my lord. They have sought time to file their reply, my lord. I said no problem, they can file, and 2-3 dates were given, my lord, for the purposes. Now they are saying I am ready for argument at any moment. But if they again say okay, we'll have to file reply, that is what I want the situation to be clarified. If they don't want to reply, Lordship may kindly
My
fix
lord,
it
it may be recorded that I'll not file an affidavit, my lord. On the basis of material available on record, matter can be decided, my lord.
Can be hard and decided.
Please, my lord, Lordship may kindly fix up the date. And my only submission is, my lord, I'm out of station.
The thing is
lawyer
that
from Delhi.
there are two different things. See, affidavit which you file as per your own desire, and affidavit which the court directs are two different things. If court directs, you cannot say we will not file. That is what the problem is, Dr. Majika.
My lord, what happened, my lord? When the hearing took place, my lord, one point I am required to clarify, that is there in the order itself, my lord. May I just point out page 20, my lord, of the petition.
We'll have to reassemble after this. Give me 14, just show me.
Lordship may kindly give us the date, because I have a matter in the Supreme Court and I'm online, and I have fixed up the time from the Chief Justice at 2 p.m. my lord. So, my lord, and I never know as to how long my matter will go in the Supreme Court. So my submission is, my lord, that it may kindly fixed up for an argument on any date which is convenient to this honorable court and my brother opposite side.
What is the order by which affidavit is required to be filed?
My lord, I sought leave, my lord, from my lordship to file an affidavit on 9th June 23.
Okay, the petitioner argument is not concluded.
Please, my lord. I have not argued. They have sought time for the
Yes,
reply,
yes,
my lord.
yes. It's all right. It's all right. Now that was done at your on your prayer.
On my. So now I'm submitting, my lord, the affidavit. We are not filing an affidavit. Why, my lord? Because our stand is reflected in the order itself, my lord, the impugned order itself.
Okay, just item 14. Just item 14. Right. Hard, Mr. Who is SQ Kazim? Are you Mr. Kazim?
Please, my lord.
Yes.
Please, my lord. This is Dr. S.Q. Kazim, my lord.
Yes. Learned counsel for the.
And my lord, I'm
Yes.
saddened
Hold on.
that
This court is passing an order. Please.
Please, my lord.
Heard Dr. N. Majika, learned DSGI, who submits that there is no requirement of filing any affidavit on behalf of the respondent, as the contention made by the respondents are reflected in the impugned order itself. Let's go on. In view of the matter, in view of the submission, the respondents are not required to file any affidavit. Stop. The matter may get taken up for hearing. When shall it be listed?
Lordship may kindly list it in October. Lordship, any date which my lord is pleased to.
This is very
In
difficult.
October,
Very difficult to say when the court will is free. October means we are in.
Then my lord may kindly fix it up. Exactly, Lordship may kindly fix it up on second. I mean, the second is leave. The third of October.
We may not give you exact date right now. We will give you probable weeks. Will be.
Lordship has all powers, my lord, to fix it up.
The difficulty is that, you see, if you give you a date, and on that date, if you find there are many other matters also, then fixing a date would become useless.
Lordship, can I have an alternative, most humble submission? It may kindly be fixed at the time, my lord, at 12 evening, whenever it is placed, my lord. At 12. At 12 noon, my lord, if it is fixed.
We cannot give that kind of timing. You see, we do not give. No.
I thought.
We do not give. See, anyway, list this matter.
Anyway, my lord.
This is matter for hearing after 3 weeks. What is what days? Yes, 3 weeks will be somewhere in the middle of the October.
Well, I'll be grateful, my lord. I'll be grateful. But my lord, my last submission is they should not seek time for further.
That would
argument.
depend. That would depend upon situation. You do not know what happens when.
Please,
You cannot devour everyone. You see,
please, my lord.
certain rights available to all the parties.
I'm grateful, my lord.
Yes.
Your Lordship, I pray
I'm
to
grateful.
adjournment of item number 15.
Item number 15. How many matters are there after the case? 15. Only 15 or?
Number 9 is also there, my lord.
Yes.
8 as well, my lord.
Yes. It's okay. It's all right. We'll sit again. If it is taken up, there is no problem in it.
My lord, 9 I was praying for some accommodation. The other side, who's the other side?
9 on the prayer of who? Who is the other side?
Mr. Patak from Guwahati. I don't see.
Nobody is there online.
I'll
Item
inform him.
number
my lord.
15.
Yes. On the prayer of Mr. Majika, Mr. Dr. Majika, Learned counsel for the respondent. List this matter after 2 weeks. Item 9.
Your Lordship, item number 15.
15. What happened 15?
Actually, I pray for 2 weeks' time, Your Lordship. The conducting counsel has some personal difficulty, Your Lordship.
Yeah, for the petitioner.
Yes, Your Lordship.
Okay, on the prayer of learned counsel for the petitioner. List this matter after 2 weeks.
Yes. Obliged, Your Lordship.
Your Honor, a joint prayer for item number 8. I'm appearing on behalf of Mr. K.P. Bhattacharjee.
On this matter, Your
Item
Lordship.
number 8, Akhtar Ali.
Yes. On this matter, Your Lordship, the state is yet to file their affidavit.
Your Honor, my instructions were that the affidavit was filed in a similar matter, and that matter was disposed of. I mean, there was some contention with regards to
Affidavit
the
in
affidavit.
opposition in 2019 matter. It has not been filed till now.
Your Honor, there was a contiguous matter, and in that the affidavit was filed, and that matter was disposed of.
Then,
So,
which
Your
way
Honor,
it solves the problem of filing affidavit here?
Your Honor, I seek for two weeks' time.
The last order speaks about filing of affidavit. Just give me item 8. On the last occasion also on the joint prayer it was adjourned. But then where is the order by which it says affidavit is required to be filed? Nothing is there. See, last so many orders. This is simple, all these are plain order of adjournment, nothing. Where is the prayer for filing affidavit?
There was no prayer, but
Then?
it was submitted by my senior that they have to file their affidavit.
No affidavit has been filed.
Orders.
No, sir, no affidavit yet.
No affidavit has been filed.
No.
Are you sure no affidavit has been filed?
Your Honor, like I'm saying, my instructions are that there was a contiguous matter, and in that the affidavit was filed.
No, whether any affidavit was filed in this case or not.
No, Your Lordship.
No, Your Honor.
Now there is a prayer by Mr. Gurung on 24th February 2020 allowing him to file affidavit. And then 12th third no affidavit, to office notice 12th no affidavit is filed. Additional affidavit. Now when is the affidavit filed? It speaks of addition. Not affidavit filed. Then how come then additional affidavit comes here? This prayer of additional affidavit. R. Gurung Learned GS submits that in terms of order dated 24/2/2020, additional affidavit to bring on record of complaint is ready. In same will be filed. Additional affidavit filed by respondent number 5. But then there is no affidavit in opposition by the state. Now who is respondent number 5?
Is the headmaster of the school.
No, this is affidavit of service. Affidavit of service only. This is no affidavit. So how come affidavit comes? And then there is a prayer by the State Council for filing affidavit. Last December 2020, no affidavit. Then 11th 2021, no affidavit filed. (18/4) no affidavit filed. 29/10/21 not affidavit has been filed. So whether you intend to file it or not, you see, it cannot be 2019 matter. The matter is appearing in the hearing column, and you say that you have not filed affidavit.
Your Honor, my instructions were very limited. It is just that it was stated to me that the affidavit was filed in a different contiguous matter.
So which way it helps?
I
You see,
am.
you have made
I
a
bow
prayer here
before
for filing affidavit.
I bow before my Lord.
See, your instruction will not bind you so long there is no legality in that instruction. You have to make correct submission.
Yes, Your Honor.
There is nothing, no affidavit has been filed. So we'll go without your affidavit. Any consequence will come, you will bear with it.
Your Honor, I pray for 2 weeks' time.
Write down. The office note, the relevant office notes in this matter reveal that the state has not filed any affidavit in spite of several opportunities
Your Honor, the conducting
Provided-
counsel is on
provided
his
to
legs.
it. Wait. MS.S. Shyam, Radek GA, appearing for the state, 6 for the time for filing affidavit. You will be filing or not?
Yes,
Are you
sir.
sure you will be filing?
I'll
It
have
should
to
not be
s-
something like that. Then on the next day you come and you say you will not be filing.
Your Honor, can I go and
See,
see
you
this?
take instructions. See, we cannot come to court without having a definite set of instruction. If you say you will file affidavit, you will record it and you have to file affidavit.
I'll have to ask Mr. K.P. Bhattacharya.
So we'll say none appears for the respondents. What you say? Just cancel this order. Cancel these orders. Yes. Both the parties make a joint prayer for adjournment of the matter by 2 weeks. The the different office notes reveal that the state has not filed its affidavit in opposition in the matter in spite of taking several opportunities. So, come on. The matter stands adjourned for 2 weeks. In the meantime, it will be open for the state to file its affidavit in opposition.
Deeply.
Please, when you come to court,
Yes,
come with
sure.
definite set of
Yes, Your
instruction.
Honor. I apologize.
See,
I
when
was
it
asked-
comes to the procedural part and all, it should be you. See, it is not that you just become a puppet and say whatever.
Yes, Your Honor. Yes, Your Honor.
Anything more remains for second half.
Apologies, Your Honor.
Do you finish yesterday that judgment, reserved that file? Come with that thing, you come with that thing also. We'll try to start that after you finish. We'll just see when Bishop is coming.